And welcome everyone again. Welcome Ana Maria, Mandissa. We are about to start our Faces of the City today. And as we've been telling for those who are coming today for the first time, this quarter, we are engaging with the idea of the faces of the state in the city. The Faces of the City is a weekly seminar organized by Cubes, the research chair on spatial analysis at our School of Architecture and Planning as well, and GCRO, and Sarita, I'm not sure if I'm forgetting any organization, please correct me if I am. But today, in the presentation today, we'll be listening to Ana Maria Izar dos Santos Gomes, and she will be discussing about the right to the city from a law perspective, political struggle, constitutional and legislative process, and the production of space, based on her work on analyzing the right to the city as it unfolds in Brazil. And it will be followed by a discussion from Mandissa Chandu. Let me introduce the speakers. Dr. Ana Maria Izar dos Santos Gomes is a federal district attorney at Procuradoria-Geral do Distrito Federal, so she works for the federal government in Brazil. She holds a PhD in law from Pontifícia Universidade Católica from the state of Minas Gerais in Brazil, and a master's in geography from University of Brasília. She's a researcher at the Instituto Nacional de Ciências e Tecnologias, Observatório das Metrópoles, and at the research group on law, economics, and philosophy at PUC Minas, where she did her PhD. And she coordinates the research in economic law and urban law, and she's also at the research group on geopolitics and peripheral urbanization at the University of Brasília Institute of Political Science. She represents the Procuradoria-Geral do Distrito Federal on the Cerrado Biosphere Reserve Committee, and she's the author of the book Direito Urbanístico, uma análise crítica da produção doutrinária nacional, which she will be speaking today. And Dr. Mandissa Chandu is a South African, soon to be, Dr. Mandissa Chandu is a South African human rights lawyer, currently pursuing her PhD in law at the University of Oxford. Her research focuses on property law and the persistence of urban inequality. As a lawyer, she has been involved in strategic impact litigation cases relating to constitutional, property, spatial planning, housing and human rights law, administrative justice, and access to basic services. And previously, Mandissa practiced as an attorney and served as executive director at Ndifuna Ukwazi, a Cape Town-based NGO and pro bono law center working to advance human rights and social justice with a focus on access to land and affordable, dignified housing. Mandissa holds a master's degree in constitutional and administrative law with distinction, LLB in Bachelor's of Social Sciences from the University of Cape Town. She's currently Atlantic Fellows for Racial Equality Fellow. Thank you very much. I think we can give the floor to Ana Maria to start her presentation.
I would like to thank Sarita and Priscilla for inviting me to this presentation, and congratulate Cubes and Weeds for creating a qualified space to exchange knowledge, especially among these global South nations, which have a similar reality because we were exploited in the colonial period and continue to be in the global chains of economic production. So my background is in law, so I'm interested in the right to the city as a legal right. that is a right then that can be claimed before the judicial courts. I'm interested in finding out how effective this right is. That means how far the recognition of the right to the city by Brazilian legal system can transform the social, political, and economic structures that shape the production of space in Brazil. My research finds similarities with legal geography, because I believe that law constitutes space. By law, I mean any type of regulation issued by the state, whether by the legislative, executive, or judicial branch. But this does not mean that the other social and economic agents and political actors who also produce space should be ignored. I take a critical approach that aligns with Neubrenner's understanding, which was cited by Professor Fana in his excellent lecture on the Swazi tribute labor system in Eswatini a few weeks ago. So I believe that urban space is a dynamic reality that is conditioned by neoliberalism on a global scale, but also faces local political resistance. Milton Santos, who is a Brazilian geographer, also thinks of space as a dynamic totality and calls it used territory. The concept of used territory differs from the traditional concept of territory because it is made up not only of the physical basis, the parts of the Earth's surface where actions occur, but also of the social, political, and economic relationships that these actions create. The importance of this approach, in my point of view, is that we can extend the scope of urban studies to beyond analysis of spatial objects to include issues directly affecting the right of the city, such as identity and gender issues, for instance. Well, these are the fundamental premises that guided my research, and a portion of it was published in the book Direito Urbanístico, whose title can be translated by Urban Law, a critical analysis of the production of doctrine in Brazil. Since my primary area of interest is law, I must admit that it was not easy for me to prepare this speech in a way that would interest you. And I really hope that I will succeed. I intend to show the urban space of Brazil as a dynamic reality that is influenced by global historical political process. These processes are characterized by the expansion of capitalism as a global system of economic production and the affirmation of neoliberalism, which is the political form that capitalism currently takes. This proposal is consistent with Milton Santos' space theory, which identifies the centers of economic, political, or ideological power on the planet, as well as peripheral spaces. The peripheral spaces are subject to the directives of central spaces, according to the regulations of capitalism and neoliberalism. On the other hand, they resist these regulations not only through territorialized social political struggles, but also through the intervention of national governments depending on their inclination. I believe that the importance of this proposal is highlighting there is not a singular approach challenging the production of space by the neoliberal model, but rather a multitude of strategies that arise from distinct forms of producing space. So, beginning with the Brazilian experience, I argue that the legal recognition of the right to the city was achieved through political struggles, in which social movements challenged the social, political, and economic structures that produce urban space. The task of challenging these structures is not over. It continues to and has ups and downs. I will provide an overview of this process by showing three phases or periods in which we experienced advance and setbacks in the guarantee of the right to the city. These advances and setbacks are the result of movements of the capital and social forces at the national and global levels. The first phase involved the incorporation of the right to the city in the Brazilian Constitution in 1988, and contrasts with the global advance of austerity neoliberalism. The second phase occurred between 2003 and 2016, when a government based on trade union and social movements took office, the government of the Partido dos Trabalhadores, Workers' Party. I will call this PT from now on. And the third phase begins after 2016 coup against President Dilma Rousseff, during which the government was initially transferred to a right-wing party and later to an extreme right-wing party led by Jair Bolsonaro, which was elected democratically. In 2023, the PT took control of the government in opposition to the global political and economic movements. We don't have enough data to look at this period since it's very recent. So to start the discussion, I will present the right to the city as is it recognized in Brazilian law. According to the Brazilian Constitution, urban residents have the right to quality of life and well-being, which must be ensured by urban planning. The city statute states that the right to the city includes social rights, the right to urban land, and the right to participate in urban planning through channels or state bodies created by the state. This right is guaranteed for present and future generation, which means that the natural environment will also be part of it. Based on the Brazilian Constitution and the city statute, it can be said that the right to the city is a legal right that is guaranteed in Brazil in three dimensions. A social dimension, a dimension that is directly connected to the reduction of inequalities and elimination of poverty through a fair distribution of goods and services. I call this dimension the social dimension. Another dimension, which I will refer to as the environment dimension, is related to the ecological issue, but also to democratic appropriation of land. This dimension includes the question of ethnic identity, as the land appropriation regime in Brazil harmed both indigenous people and African people, the last one brought to Brazil for enslavement. Since the Portuguese came to Brazilian lands, indigenous people have been violently denied tenure of land. Africans and their descendants, in turn, were never given access to land. Just to have an idea, they made up approximately 58% of the Brazilian population in 1872, 16 years before slavery was completely abolished in Brazil. So we can see that social inequality in Brazil is strictly connected with the ethnic issue. The main reason why African people was excluded of tenure of land was the land law, passed in 1850. This law ended the system that recognized ownership of land to those who occupied it, and limited ownership to those who had a formal title. So it turned land into a commodity, which was crucial to replacing the colonial slave economy with a capitalism based on export monoculture. The Brazilian government also promoted an ethnic policy of a fascist nature called the whitening policy. This policy was implemented through a series of laws that encouraged white immigrants to come to the country, mainly through land concessions. The Constitution aims to reduce these historical inequalities by recognizing and encouraging the way of the production, the way of life, and the way of production of indigenous people and of the communities that came from African people and kept their traditional customs. For that, it guarantees that they will remain in the land they have occupied. This is not only a matter of justice, but also a means of safeguarding the natural environment, as the practice and production of these communities are significantly less predatory to the environment than capitalism, not only in terms of consumption patterns, but also in terms of scale of production, which is local and non-global. The Constitution also encourages other non-capitalist forms of economic production, such as producers' association and autonomous cooperatives, which are also less predatory to the environment. And finally, the third dimension of the right to the city is the political dimension. That is the right of citizens to participate in urban planning. This requires creation of state bodies with deliberative power, such as councils, conferences, and hearings, where civil society members must work together with government agents. The political dimension of the right to the city is directly related to the other two dimensions, because it allows citizens to influence how urban space is produced. And since it is, since the community involvement in the urban planning hinders the interests of capital, the political dimension has the greatest difficulty to assert itself. Well, now that we have figured out what the right to the city is in Brazil, let's look at the three moments I propose to present. The first moment was when the 1988 Constitution was issued. To understand how social and capital forces move in this process, it is necessary to compare the national scenario with the global scenario. In 1985, Brazil began a process of political openness after a 20-year civil military dictatorship and experienced a moment of political effervescence. At the same time, the country was facing a period of economic stagnation and hyperinflation caused by the over-indebtedness in dollars and economic growth without income distribution promoted by the dictatorship regime. During the process, two political forces met in conflict. On one hand, there were social movements such as the National Movement for Urban Reform, who advocated for an ideology centered on urban reform, the social function of property, civil society participation in urban planning, and the fight against social inequalities. On the other hand, forces connected to capital opposed these ideas and trusted national urban development to market forces. But while in Brazil this was the situation, in the global scenario, was marked by the advance of neoliberalism with the dismantling of welfare state. And we can see it also in the international organizations. For instance, the second Habitat Conference in 1996, for instance, focused on environmental issue and leave the talking about the state's role in reducing urban equality, which was the topic at the first Habitat Conference. Later, the Washington Consensus Guidelines for Macroeconomic Adjustment in Developing Countries were adopted by the International Monetary Fund and imposed on the countries of the Global South. This led to an increase in social inequality, which in turn had a profound impact on the guarantee of the right to the city in Brazil. And during this moment, the political actors' strategies were as follows. The social movement presented to Constituent Assembly a project for amendment, which aimed to include a chapter with directives for urban reform. these directives stress the idea of social function of property, and this would require democratization of access to urban land and preventing the retention of idle properties to avoid real estate speculation. To face this discourse, sectors linked to capital did not oppose this principle, but they changed its content. Instead of connecting it with the democratization of land access, they linked it to the efficiency in urban planning. Now, if the master plan is the basic instrument of the urban planning, then the social property would be, the social function of property would be measured not by the use given to urban land, but by its compliance with urban zoning and building regulations. We know, David Harvey and Henri Lefebvre have already demonstrated that the urban planning is highly susceptible to the interests of capital. So by linking the social function of property with the master plan, the capital has operated urban planning to use the most profitable legal urban instruments and ignore the instruments that would promote a fair distribution of land. And the second way of deactivating the right to the city was through the legislative branch. That's because most legal urban instruments that guarantee the right to the city are subject to legal regulation by the legislative branch. This branch has not drafted laws to regulate these instruments. Therefore, the judicial branch has understood that they are not allowed to apply them. The lack of regulation of legal instruments has a bigger effect on the political dimension of the right to the city. And we see that city statute says that the participatory practices are mandatory in urban planning, but municipal governments rarely set up channels for participation in the state structure. And these channels are, for the most part, the channels that has been created are, for the most part, advisory and not deliberative. Regarding the behavior of the judiciary during this time, we can argue that the legal recognition of the right to the city did not make significant changes to the jurisprudence. Since before the Constitution, the judiciary has been showing flexibility in relation to land occupations. It can be understood as a movement called an official law. This can be described as a tendency of judges to ignore the law and use jurisprudential constructions to solve conflicts when there is a risk of sudden and violent change in the political system. Because of pressure from land occupiers, the state's legal apparatus became less rigid in the period preceding the Constitution. After the Constitution, there has been a great resistance among jurists and judges to apply the new constitutional system and legal system. Although this new system is no longer based on liberal individualist ethics, they continue to interpret the Constitution and the laws based on this ethic. Just to clarify, Brazilian Constitution is based on two ethics: the ethics of solidarity, which means that the state is obliged to act to eradicate poverty and reduce social inequalities, and the ethics of authority. That means that the state recognizes ethnic and cultural diversity as something enriching human coexistence and therefore worthy of protection. Talking specifically about the urban policy, the property continued to be interpreted strictly according to the civil code, and the right to the city was never mentioned in court decisions. This can be explained by the fact that judges are part of the capitalist system, and therefore They are influenced by the political ideological structure that supports this system. The second movement I would like to bring up for reflection is between 2003 and 2016, when there was a reorientation of national urban policy. In 2003, Lula, the candidate of PT, became president. It was the first time that a movement supported by social movements took the presidency. The period when PT ruled the country was marked by a policy of economic expansion and poverty reduction. During this period, the Congress passed the Urban Regularization Law. According to the law, the urban land regularization should include measures to minimize environment damage and to implement urban infrastructures. Despite this advance, legislative initiatives that should have been implemented by municipal governments to make urban land more accessible were not. For instance, the city statute provides many legal urban instruments that can democratize access to land, besides the urban land regularization. One of them is the IPTU progressivo, which is a progressive land tax that penalizes owners who leave their properties idle. Other one is the Zonas Especiais de Interesse Social, that can be translated to special social interest zones, which designate specific areas for low-income housing. The municipal master plans have hardly included these instruments. On the other hand, instruments like joint urban operations and public-private partnerships have been used extensively. And as we know, these instruments help to accelerate urban renewal, which is important for the reproduction of capital, but has a negative impact on social and economic costs because they encourage gentrification. By failing to include illegal urban instruments that could make land use more equitable, the municipal governments undermine the right to the city. Since the social function of property is tied to the master plan, it is hard to challenge such decisions in court. During the first period of PT government, Brazil managed to get off the hunger map and include a large part of the population that didn't have access to goods and services in the consumer market. It adopted an income redistribution policy that has had a direct impact on the population's access to housing, basic sanitation, electricity, and other social rights. This policy was able to reduce the number of people living in poverty from 30% to 15% between 2001 and 2008. The urban policy emphasized democratic management of the cities. The number of collegiate state bodies with members from civil society increased, although few of them were assigned to assume effective deliberative functions, and social leaders from all the levels came together at city conferences to discuss national urban policy. But in 2007, there was a turning point in Brazilian urban policy. The government launched the Programa de Aceleração do Crescimento. We can translate it to Growth Acceleration Program. The purpose of the program was to expand infrastructure and domestic market, but it started to be used as a counter-cyclical measure to deal with the global economic and financial crisis of 2008. At this moment, the government leave aside the principles and guidelines of the National Urban Development Policy, including the democratic management of cities. If we take a look at the design of the program named Minha Casa Minha Vida, which was part of this major program, PAC, we can see the effects of this approach. The program was launched in 2009 to finance the construction of housing. just to start with, it was not led by the Ministry of Cities, which is responsible for urban planning, but by the Ministry of Planning and Finance. The social movements did not participate in the planning of the program, but representatives of the real estate and construction industries did. The program achieved excellent financial results, more than 4 million and 200,000 housing units, 200,000 housing units were built, which helped around 10.5 million people. But it did not consider the importance of regularizing land to avoid the displacement of people from occupied areas. Also, as housing production was done by the private market and no investment to infrastructure was required from them, from the entrepreneurs, the houses were built far from urban centers and did not have access to basic services. And this fact, combined with the stimulus to the automobile industry, which was also used as a counter-cyclical measure, and the low investment in public transportation system, precisely because the market was not interested in the service, led to an increase in the time people spent in traffic, which had a negative effect on the quality of life in Brazilian cities. Regarding to the judicial behavior, from 2003 to 2016, we observed that it was less tolerant for collective occupations in favor of the discourse of environment sustainability that was separated from social justice. The social function of property was very used, but it gained significant rhetorical power to guarantee the right of homeliness. Now, it has gained significant rhetorical power to condemn collective occupation of areas with natural attributes and not to guarantee the rights of the homeless. The last phase of urban policy that I want to talk about is the return to power of the right wing and subsequently of the extreme right wing in the person of Jair Bolsonaro. There are numerous factors that contributed to 2016 coup against President Dilma Rousseff. However, I will concentrate on the series of protests that occurred in June 2013, subsequently referred to as the June protests. These protests took place in the country's major cities just before the World Cup and the Olympic Games. The initial purpose, which would be held in Brazil, the initial purpose was to protest the increase in public transport fares, but this object later expanded to demand social rights in general and criticize the lack of investment in public policies in favor of spending on mega sporting events. And just to provide an idea of the objective of this protest, the protesters' main slogan was, "We want FIFA standard hospitals." Here we have in the images people protesting. We can translate the slogans to "The World Cup is here and health hasn't even arrived" above, and the other is, "If the bus fare doesn't drop, the city will stop." And to understand why people were protesting in an economic situation favorable as it was in Brazil in 2013, we must examine the urban policy. Real estate prices went up sharply in the lead up to the Olympic Games and the World Cup. In São Paulo, the most populous city in Brazil, real estate prices increased by 200% between 2008 and 2014, and rental prices increased in the same amount. So we can conclude that even though the working class increased their wages, it did not result in a better standard of living. The rise of the high right-wing government in 2016 opened way to an austerity economic policy, which had a profound effect on the guarantee of the right to the city. The national participation system was deactivated. The legislative branch approved a constitutional amendment that imposed restrictions on government spending on primary expenses. This affected the promotion of income redistribution policies and consequently the reduction of social special disparities. Investments stopped in housing, sanitation, and urban mobility sectors. A new legal framework opened basic sanitation to the market without guaranteeing affordable rates for users and universal coverage. Another important event is the approval of a law that allows land regularization without the adoption of measures to minimize environment damage and implement infrastructure. Just granting the property title to people. That clearly interests the market, who wants to buy land to requalify urban space. And finally, it's worth mentioning a proposition of constitutional amendment, it's just a proposition, authored by Senator Flávio Bolsonaro, who is the son of the former president. The proposal was not yet approved, but is still being processed in the Congress. In according to it, property will only be recognized as having a social function if it does not affect third-party rights, any third-party right. In practice, this means that the principle will not be applied in any situation. And it also proposes that any expropriation resulting from non-compliance with the principle, the social function of property, shall be based on the market value of property, which rewards the owner who kept his property idle. Concerning to the environment dimension of the right to the city, this period was marked by attacks to the rights of indigenous people, increasing violence against vulnerable people, and persecution of environment, anti-racism, and gender equality movements. So all these measures contributed to a worsening of a social spatial inequality up to 2023, when President Bolsonaro's government ended. And how was the conduction of what was the judiciary's conduct during this time? As was the case before the Constitution, the actions of the judiciary during this period were geared towards protecting the property of vulnerable individuals, especially because the period coincides with the COVID-19 pandemic, which has affected the economy. One example of this is the judgment of PDF 828, an action for non-compliance with federal precept filed by one party called Partido Socialismo e Liberdade, which can be translated to Socialism and Liberty Party. The judicial action was proposed to ensure the right to housing in the face of threats of collective forced removals. And in this judgment, the Supreme Federal Court decided that collective eviction actions should be suspended until the end of 2022, and that the transitional regime should be set up after that date. This transitional regime involves mediation hearings between the parties in land conflict, and these hearings will happen in land conflict committees created in all courts in the country. And this achievement reflects the mobilization of the Campanha Despejo Zero, or Zero Evictions campaign, which was promoted by a network of organizations and social movements. So, to end my presentation, the conclusions of this paper are, first, I argue that the Brazilian Constitution and City Statute have failed to reverse the social spatial inequality that characterizes Brazilian cities. The situation should not only be seen as a legacy of the colonial slave-owning past, but also as a reflection of the progress of neoliberalism on a global scale since 1980. Two, there were advances and setbacks in the process of ensuring the right to the city, since there is a constant tension among the forces that produce urban space. This dynamic is strongly influenced by the movements of capitalism on a global scale. Three, the judiciary's conduct shows a tendency to interpret legislation in a way that protects the vulnerable people during times of crisis. In this way, it prevents major disruptions of the political structure and ensures social peace. However, it has not done the fundamental task of changing social, political, and economic structures, which was assigned by the 1988 Constitution. 1988. The analysis of the three moments of Brazilian urban policy shows that the social forces mobilized during the constitutional drafting process were successful in producing a document that transcends liberal individualist ethics and affirms the ethics of solidarity and authority. But the forces of capital were able to deactivate the conquest through legislative strategies. The PT government initially encouraged civil society participation in urban planning. However, from 2008 on, it adopted counter-cyclical measures to safeguard the nation from the global financial and economic crisis. These measures have had negative effects on the quality of life of Brazilian citizens. After the 2016 coup, the right-wing and extreme right-wing adopted a policy of economic austerity in accordance with the neoliberalism model. The social participation system was taken down, and social forces could not organize themselves to claim their rights. So the Brazilian experience, my point of view, confirms Neil Brunner's suggestion that urban reform agendas are vulnerable to be captured by the market unless they are accompanied by supralocal projects of counter-neoliberal institutional policies and spatial transformation.